Good morning, everyone. Welcome to Assembly Judiciary, to everyone here in Carson City, as well as anyone there in Las Vegas, and of course, anyone watching on Nellis or through our YouTube station. Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Orentlicker, Roth, Urick, Chair Miller.
Here, thank you. And with that, just a few reminders. Please turn off your electronic devices. Also, information about today's hearings are on Nellis. This includes the phone number to call in with the meeting ID if you're wishing to make public comment or to testify on any certain bill. We will have public comment at the end of today's meeting. With public comment and testimony, we ask that everyone keep their comments to 2 minutes. Also, you may submit any written comments up to 24 hours after the meeting. We also ask that presenters try to keep their presentation to 15 minutes so that we have time to get through everything. And just a reminder that public comment is for the things that are under the purview of this committee, meaning there are certain supervisor roles that we do not have authority or jurisdiction over. Of course, I thank you already for the courtesy and respect that everyone always exhibits here in Assembly Judiciary. With that, we have 3 bills today. 2 will be presented from the Attorney General. So with that, I will open up the hearing for Assembly Bill 34. Assembly Bill 34 revises provisions relating to certain crimes. And so with that, I will welcome the Attorney General up. Please introduce yourself and spell your name correctly for the record. Also a reminder, very difficult for us all to get into the habit of, but before you speak, please make sure you say your name. First time I ask that you spell it so we have it correct for the record, but before you speak, always please make sure you say your name. And Attorney General Ford, we are ready whenever you are.
Thank you, Chair Miller. My name is Aaron Ford, Aaron, last name Ford, and I'm your Attorney General. Great to see all of the Assembly members here today. I am here to present Assembly Bill 34 for your consideration. As you've already heard me say earlier this session, one of the guiding principles of my office is criminal justice and reform. And AB 34 is sound policy that will aid prosecutors in bringing violent and sexual offenders to justice, as well as help victims know that they can be safe from being re-victimized in the future. As I've stressed both in this committee and elsewhere, ensuring that public safety and reform are not competing values. I believe in accountability for those who harm others, as well as a justice system comprised of human dignity and fairness. I'm proud to say that my staff and I have successfully prosecuted dangerous criminals, ensuring a safer Nevada for all. I'm also quite cognizant of a prosecutor's duty to the victims of crimes that are committed. No 2 victims are alike, and those individuals who are the most vulnerable in our communities, namely children and those with mental illness, need additional assurances that they will not be re-victimized by those convicted of violent offenses against them. Currently, existing law prohibits a court from deferring judgment on a case if the defendant has been convicted of, and I quote, a violent or sexual offense, unquote. This bill expands the definition of violent or sexual offense to include other crimes in which the victim is a child or a person with mental illness. Additionally, this bill expands the list of crimes for which probation or a suspended sentence is not an option for courts to contemplate if the defendant has committed the crime of attempt lewdness with a minor, and their psychosexual evaluation returns as a high risk to reoffend. At this time, I would like, if the chair indulges, to turn the presentation over to Alyssa Engler in the South, who is my Chief of Prosecutions at the Attorney General's Office, to provide a brief section-by-section overview of the bill.
Thank you, General Ford, and good morning, Chair Miller and members of the Assembly Judiciary Committee. My name is Alyssa Engler, and I am the Chief Deputy Attorney General in our Criminal Prosecution Division of the Nevada Attorney General's Office. I'll take this opportunity to explain the intent of this bill and answer any questions the committee members may have. Section 1 of this bill adds the following offenses to the list of violent or sexual offenses under NRS 202-876. Subsection 12 will be expanded to include NRS 200.727, which is the use of internet to control visual presentation depicting sexual conduct of a person under 16 years of age, and NRS 200.730, which is possession of visual presentation depicting sexual conduct of a person under 16 years of age. These are both Category B felonies. Subsection 16 adds NRS 201-540, sexual conduct between certain employees of a school or volunteers at a school and a pupil, a Category C felony. Subsection 17 adds NRS 201-550, sexual conduct between certain employees of a college or university and a student, a Category C felony. And subsection 18 adds NRS 201-560, luring a child or person with mental illness, Category B felony. By adding these offenses to the list of violent or sexual offenses under NRS 201-876, the court is not allowed to defer judgment against an individual convicted of these crimes under NRS 176-211. This bill adds to the list of already existing crimes against children and persons with mental illness where deferred judgments are not allowed. Deferred judgment should be reserved for nonviolent, non-sexual offenses for which these added offenses are not. Additionally, by adding these offenses to the list of violent or sexual offenses under NRS 202-876, the court would now be allowed to extend the probation period for these offenses to not more than 60 months. Under current law, NRS 201-540 and 201-550, which are Category C felonies, the max probationary period under NRS 176A.500 is 2 years. Under current law, NRS 202-727, NRS 200-730, and NRS 201-560 are Category B felonies, so the max probationary period is 3 years. With this law, the court can grant probation not to exceed 60 months or 5 years for those stated offenses, which will allow pro and probation additional time to monitor these offenders. Some additional benefits will include an extended length of the no contact or stay away orders for the victims, which often accompany probation. It will also give sex offenders additional time to complete sex offender treatment or other court-ordered therapy beyond the 12 months that's already built into statute. Additionally, by adding these offenses to the list of violent or sexual offenses, PMP is no longer obligated to recommend an early discharge from probation if the conditions of NRS 176A.840 are met. I will note that under subsection 2, it still gives the court discretion to grant an early discharge for these crimes. For example, if a defense attorney files a motion requesting early discharge and the court is persuaded by the argument, they can still grant the early discharge. Lastly, by adding these offenses to the violent or sexual offenses under NRS 202-876, there's now a mandatory duty to report an incident of this type if the reporter knows or has reasonable cause to believe that a person has committed these added offenses to a child who is under the age of 12. Lastly, moving on to Section 2, this bill adds the crime of attempt lewdness, which is a Category B felony, to NRS 176A.110. This precludes a court from granting probation if a defendant returns as a high risk to reoffend on their psychosexual evaluation. Under current law, this crime is not listed as an offense that would preclude the court from granting probation under these circumstances. Thank you for the opportunity to explain the intent of this bill, and I'll now turn it over to the committee members for questions.
Thank you so much. We will begin questions with Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for bringing this. As a teacher, I find the acts that you are trying to capture here absolutely abhorrent, and I appreciate what you're trying to do. My question is just on Section 16 and 17, where we're talking about conduct between employees of a school and a pupil. Obviously, we want to capture that, but there are other situations where adults are taking advantage of children in group leaders or in church leaders or in coaches or other places. So how are we capturing that portion where children are being victimized?
Thank you, Madam Chair. Direct.
Please go direct. Thank you.
Thank you so much for the question, Assembly Member LaRue Hatch. I'm going to defer and refer to my colleague in Southern Nevada. I do know that we've entertained the question before relative to bills of similar nature, but let me allow my colleague to respond to your question.
Thank you, Alyssa Engler, for the record and permission to go direct.
Please. Thank you.
Thank you. So to answer your question, the conduct that you are referencing, we can find under subsection 18, which is luring a child. That doesn't have to distinguish. That can be a teacher, that can be a coach, that can be a church member. Anytime you're luring a child away from their family for any sort of sexual gratification, that's covered under NRS 201-560. Additionally, there's already existing crimes under 202-876 that are defined that would be covered under here, or would be covered for the conduct that you're referencing. So although there's not a specific crime listed like the sexual conduct that we see in 16 and 17, criminal conduct can be covered under subsection 18, which is luring a child.
Thank you, and I appreciate that we're capturing that because I know your intent is not to leave anything out. My question then, follow-up, is why do we need to explicitly include those carve-outs for schools? Was there some loophole or some way that they were slipping through that is not currently covered?
Chair Miller.
Thank you.
Sorry, Teresa Benitez Thompson, for the record, Chief of Staff to AG Ford. I'll pass it down to Chief Engler here, but just wanted to do as a reminder, so last legislative session, our office brought forth, and this committee heard, a piece of legislation which established, as you look at Section 1, the sexual contact between certain employees within the school setting, that was the bill that was heard last session in which we had a lot of this conversation. We worked with the DAs and Clark County School District. They brought forth from Clark County School District, their investigators, certain instances and cases and behavior that they found very disturbing, that they wanted to be able to codify into statute as being able to take action on. And so a lot of that conversation about why we put them into statute just to memorialize those as crimes was had last session. I'll let Chief Engler speak more to about why we wanted to make it neat and tidy in terms of closing it on this end, and I'll pass it down to her.
Thank you, Assembly Member. Again, Alyssa Engler for the record. The intent of this bill is to add these to the violent and sexual offense so that we can expand the monitoring for these specific type of crimes. What we were hearing from the prosecutors who were handling this is that individuals who were accused of these crimes would be getting off of probation after a short period of time. And given that these crimes involved children, we wanted to be able to have the Department of Parole and Probation the option, and courts the option, to extend the period of time. It's not an automatic, it's still at the court's discretion, but have that option to monitor them. And specifically, these are the crimes that are already codified in statute, and that's why we're looking to add them to NRS 202-876.
Thank you for that. Right now, I don't see any additional questions. So I will open it up for testimony in support of Assembly Bill 34. We will start here in Carson City first, and then move to Las Vegas, and then move to the phones. So anyone wishing to make testimony, again, just a reminder, please state your name and spell it for the record. And also, please try to limit your comments to 2 minutes.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. Jennifer Noble, Jennifer Noble, Noble, On behalf of the Nevada District Attorneys Association, I'd just like to thank the Attorney General for bringing this important piece of legislation, which will help ensure appropriate accountability and monitoring for those offenders who abuse positions of power in our schools and positions of trust by victimizing Nevada's children. We appreciate this bill, and we hope you take it into serious consideration. Thank you.
Good morning, Chair Miller, members of the committee. My name is Jason Walker, Jasonwalker, representing the Washoe County Sheriff's Office as well as the Nevada Sheriffs and Chiefs Association, testifying in support for Assembly Bill 34. Thank you.
Not seeing anyone else here in Carson City to testify. Is there anyone there in Las Vegas that would like to testify in support? Not seeing anyone, I will go ahead and provide the phone number for anyone wishing to call in. The number is 1-888-475-4499, and the meeting ID for today is 826-6732-7258. And also that number is provided on the agenda that you can locate on Nellis. With that, broadcasting, will you please open the line?
If you would like to testify in support of Assembly Bill 34, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support of Assembly Bill 34, please press star 9 now. Chair, the public line is open and working. There are no callers choosing to testify in support at this time.
Thank you so much. With that, I will go ahead and open it up for testimony in opposition of Assembly Bill 34. Not seeing anyone approach here in Carson, is there anyone there in Las Vegas that would like to testify in opposition? Not seeing anyone, broadcasting, will you open the lines?
If you would like to testify in opposition to Assembly Bill 34, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. With that, I will go ahead and open it up for testimony in neutral for Assembly Bill 34. Not seeing anyone here in Carson City, is there anyone there in Las Vegas that would like to testify in neutral? Broadcasting, please open the lines.
If you would like to testify in neutral for Assembly Bill 34, please press star 9 now. Chair, there are no callers wishing to testify in neutral at this time.
Thank you. With that, I will welcome the Attorney General back up for any final closing remarks. Okay, thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 34. Our next bill this morning, also on behalf of the Attorney General, is Assembly Bill 63. This revises provisions relating to civil actions for wrongful conviction. Members, I trust that you have pulled and reviewed the proposed amendments to Assembly Bill 63 as well. And with that, the hearing is open, so you may proceed when ready. And please also introduce everyone presenting with you today. Thank you.
Good morning again, members of the committee. My name is Aaron Ford. I am your Attorney General. Chair Miller, thanks so much for allowing us the ability to present Assembly Bill 63. I am accompanied by my colleague, Heather Proctor, who is the chief of our post-convictions unit, who will assist in presenting this bill. In 2019, the legislature created the wrongful conviction compensation statutes. My apologies. I also have Jamie Steels down in Southern Nevada, who will likewise be assisting me in presenting this bill. My apologies. In 2019, the legislature created the wrongful conviction compensation statutes, now codified at NRS 41.900 through 41.970, authorizing a person who is not currently incarcerated for any offense and who was wrongfully convicted and imprisoned by the state to bring an action for damages and other relief in state district court. The Office of Attorney General has worked with claimants in balancing the state's obligation to be fair and just with its responsibilities to ensure that it is not overwhelmed with enormous monetary liability. To that end, the office ensures every claimant complies with NRS 41.900 and establishes, by preponderance of the evidence, that they did not commit the crime for which they were convicted. The intent of the wrongful conviction compensation statutes, as addressed in the 2019 legislative history, is to provide monetary support for persons recently released from prison or parole to permit them to begin rebuilding their lives and to reenter society, and for the state to do what it can to restore their dignity in life after years lost from being wrongfully convicted. An award does not place blame or find fault. Rather, the person is provided support to begin living a normal life with a certificate of innocence that allows that claimant to move forward without the wrongful felony conviction looming over their record, and compensation to aid in rebuilding their life. AB 63 seeks to clarify the existing law on a few points. For that section-by-section analysis, I will turn the presentation over to Senior Deputy Attorney General Jamie Stills down in Las Vegas.
Thank you, AG Ford. Good morning, Chair Miller and members of the committee. For the record, Jamie Stills, J-A-I-M-I-E-S-T-I-L-Z, Senior Deputy with the Nevada Attorney General's Office. As AG Ford mentioned, AB 63's purpose is to clarify the existing law. First, Section 2 of AB 63 seeks to amend NRS 41.950, which governs the awards and benefits a person may seek in a wrongful conviction compensation action. This section has distinct changes. Initially, a person who receives an award for wrongful conviction compensation is entitled to a monetary award of damages based on the number of years served in prison and/or on parole. Separately, a person may also receive other monetary benefits, such as assistance with tuition, housing, counseling, and health insurance. Both the damages award and benefits are paid upon approval of and by the Board of Examiners. As detailed in NRS 41.950 subsection 2B, the statute specifies the BOA provides payment for the cost of these benefits. Section 2 alters the term payment to reimbursement. This change reflects the original legislative intent, as borne out by the current practice of the BOE, to reimburse for actual expenses the person already paid for such benefits, rather than direct payment to third parties. Further, in 2021, the legislature created subsection 6 of NRS 41.950, which applies a maximum to the benefits outlined in NRS 41.950 subsection 2B that a person can receive. The cap is set at $100,000 per calendar year for a length of time equal to the period the person was wrongfully imprisoned. The cap was intended to include all monetary benefits. In other words, all money expended in such cases other than the initial damages award and attorney's fees. However, that amendment contained a clerical error, as the miscellaneous provision, any other relief, should have been included in that cap under subsection B. The 2021 amendment inadvertently created a separate category of reimbursement. The proposed amendment corrects that clerical error by moving the catch-all any other relief within the $100,000 cap for benefits reimbursed in any calendar year. Next, the Attorney General's Office has submitted a proposed amendment to Section 1 of AB 63. That amendment makes two changes. First, the amendment reverses the alteration in the existing Section 1 of the bill and returns to the original language in NRS 41.900 subsection 1 of incarcerated, and instead adds a definition of incarcerated to subsection 6 to mean a person who is in jail or prison. NRS 41.900 subsection 1 is a preliminary requirement that a person must meet before filing a wrongful conviction compensation complaint, that they are not currently incarcerated. The reason for this requirement again goes to the intent of the statute, to permit those wrongfully convicted to resume a normal life outside of prison. A person who is currently incarcerated, as defined in the proposed definition, does not face the same difficulties as a person who is released to society and must rebuild a normal life. The term incarcerated appears only in this portion of the wrongful conviction compensation statutes. All other references regarding custody status use the term imprisoned. The term imprisoned is largely accepted to refer to a person under a sentence in the Nevada Department of Corrections. There's been some confusion among parties and judges as to whether incarcerated means the same thing as imprisoned. This distinction is critical, again, as this section of the statute sets forth the basic requirement a person must meet to even file a complaint seeking compensation. To clarify the law, we now define incarcerated to mean a person who is in jail or prison at the time they seek to file a complaint. In doing so, the intent of the statute remains intact, to limit compensation to those wrongfully convicted who are actively attempting to rebuild their lives anew in the world. Finally, our proposed amendment to Section 1 of AB 63 addresses the standard a person must meet to qualify for wrongful conviction compensation. NRS 41900 subsection 2D requires a person meet one of three criteria. The issue we have found in litigating these cases, though, is that the requirements in subsections D1 and D2 are not clear. In practice, under these provisions, a person must have their judgment of conviction vacated, the charges dismissed, and the basis for the dismissal of the judgment was not legal error. This reading of the current statute is in line with other provisions of NRS 41.900, which require a person to prove that they are actually innocent of the original charged offense and any acts associated with that original offense. If a judgment is reversed for a legal error, that does not mean that the person is innocent of those charges. We therefore propose to amend subsection D to clarify the distinction between the first and second criteria as they exist in the current law. We believe this clarification will assist recently released persons, their attorneys, and the courts in understanding the criteria required to qualify for compensation. Thank you. This concludes our presentation of AB 63 and our proposed amendment. We're happy to take any questions the committee members may have.
Thank you so much. With that, we will open it up for questions, beginning with Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. My question is in regard to the language regarding custodial status moving to incarceration. I understand the intent is to clarify that there's been some misunderstanding or disagreement among judges. But I'm wondering if this language also captures those who are on parole and probation.
Thanks so much. Aaron Ford, for the record. I forgot to spell it the first time. AARON, last name FORD. Senator Roth, a great question, and I just want to be certain that you're referencing the amendment that we provided, because I think you're referencing the original language of in custody. Is that right?
No, I apologize. I'm looking at the amendment, and it crossed out in custody and put incarcerated.
Yeah, the original language in the bill was incarcerated.
Okay.
And we initially had tried to change it to in custody. But because of the concern you just raised, how in custody can encompass a lot more than simply being in jail or in prison, and it can include parole, for example, we went back to LCB and asked for a better way to describe the circumstances we were trying to address. And the fact is, we had people who were in jail trying to file these petitions. And that was not the intent of the bill. And so we want to cover that. And the idea was to simply just define incarcerated to mean either in jail or in prison. And so that's what the amendment provides in this regard. But allow me to offer either Jamie or Heather an opportunity to augment what I've said, or even to correct it if I'm wrong. Aaron Ford, for the record, looks like I was right.
Chair, can I ask a clarifying question?
Yes, please.
Thank you so much. So just for clarification, because I want to make sure I'm looking at the right thing. So it does not include those who are on parole and probation?
Aaron Ford, for the record, you are correct.
Okay, thank you.
Thank you. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. So many questions. Actually, I'm going to tie this one in. Assemblymember Roth had a good segue for me. Why, if somebody's exonerated of a crime, yet they're incarcerated for something else, why would we deny them that right? And I mean, I've got other questions, but that one, I mean, especially if they're incarcerated, it's still going to make their lives better. And it's also been stated by your own staff when they're attempting to rebuild their lives. So there's an assumption there they may wind up back in trouble again. And, you know, a lot of times that's just a result of them spending time in prison.
Aaron Ford, for the record, and again, I will defer to Ms. Stills if she wants to chime in on this. But I will say, Assemblymember Gray, that's a policy question for the legislature, frankly. When this bill initially passed, it was not intended to allow those who were still either in jail or in prison to pursue this remedy. It is for those who are in society, attempting to rebuild their lives, irrespective of what other crimes may be involved or engaged in. So if you are in jail for another crime, you are not in society trying to rebuild your life, and therefore, at least at that juncture, aren't eligible to apply for wrongful conviction relief under this particular statute. And that was, as I understood it, the initial impetus or the initial rationale in 2019 when this initially passed. Chairman Yeager, Speaker Yeager. Now Speaker, then Chairman Yeager, I believe, when he sponsored the bill. Jamie, do you want to offer anything additional?
Thank you, AG Ford. For the record, Jamie Stills, through the chair. AG Ford is correct. That was the original intent as far as we understand it, which again, simply is to assist with people who are out in society. And frankly, what we have seen is that people who have attempted to file wrongful conviction complaints while still incarcerated in jail or in prison have not been re-entering society. And once they do release, they do have the option to pursue this type of action. So once they have the ability to try and rebuild their lives, they will be able to bring a complaint. It's just simply during the time period while they are incarcerated, they're just not entering society. And we believe that this is not the intent of the statute, is to not allow them to file one of these until they are trying to rebuild their lives outside of an institution. Thank you.
Member Gray, would you like another question?
Thank you, ma'am. And this is a question that you just brought up. So the intent of this law is to help them rebuild their lives. It's not the intent to make them whole for prosecutorial misconduct or a wrongful condition. I mean, usually when you bring an action, it's to be made whole, not to reestablish your life.
Aaron Ford, for the record. Assemblymember Gray, great question. The short answer is that no, this bill is not intended to make them whole. That's what we call a 1983 action, a civil rights complaint that will be filed generally in federal court to do exactly what you've just talked about. This was intended to provide some level of recompense for the wrongful actions that our state undertook in prosecuting someone and wrongly convicting them. So that's the answer to the question.
Okay.
Thank you. Do the members of the family, and I'll use the term victim in this case, do the members of the victim's family have standing since they've been injured as well?
Aaron Ford, for the record, the answer is no. This is only for the defendant. Pardon me 1 second. You want to jump in?
For the record, Heather Proctor, Heather Procter. The award of monetary award is intended for the defendant. There are additional benefits that the defendant can apply for, and there is a certain level that the family members can also receive, such as counseling through those benefits. But the primary monetary award, the certificate of innocence, is intended for the defendant.
Thank you.
Thank you. We have another question from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for answering all our questions today. You might not have this number right off the top of your head, but I just wondered how many people have been found factually innocent since the inception of the statute? Is that look, we knew that was coming?
Heather Proctor, for the record, I would defer to my colleague in Vegas for those numbers.
Thank you. For the record, Jamie Stills, through the chair. At this point in time, we have found and issued 8 certificates of actual innocence and awarded damages and benefits to those 8 claimants. We have 5 pending active cases as well.
Thank you so much. Just a follow-up to that question is, in terms of time, the process, we know this is a lengthy process. Do we know, and I know we just have a handful of cases so far, how long it takes from the time for us to not just to to identify the wrongful conviction, but also then to actually start and proceed. So if we can, I know we had one of our first cases in the state, it was what, almost 20 years, if I recall. But do we, now that this process is in place, do we have an average time frame?
Aaron Ford, for the record, we're going to refer that to my colleague Jamie in Southern Nevada.
Thank you. For the record, Jamie Stills through the chair. Unfortunately, we don't have an average at this point in time. Each case is so unique and different. We have several cases that moved fairly quickly. I believe were resolved within about 6 months after all the appropriate documentation had been provided. The attorneys established all the paperwork and agreed on the documentation to be submitted to the court. We have other cases that have been pending for several years because different questions and concerns about whether the statutory requirements were actually met. So it's really a very distinct, unique, fact-based situation for each separate case. Thank you.
Thank you for that. Our next question is from Assemblymember Hanson.
Thank you, Chair, and thank you for being here. This was probably one of the most fulfilling sort of votes I ever made in 2019 as a freshman, and won't ever forget DeMarlo Berry and his story and his grace and his forgiveness. So to revisit this just brings up a couple things to clarify. On subsection 1, section 2, 2B, where we go from payment to reimbursement. I just want to make sure I understand it correctly. It's that the reimbursement, the victim or the person who's been compensated, they pay it directly. It's not the state, or the compensation isn't going to go directly to a vendor of some sort. Is that how it was playing out?
For the record, Heather Proctor, that is correct. The practice has been with the BOE to reimburse the defendant for these costs rather than establishing for the BOE to pay these third-party vendors directly. Board of Examiners, excuse me.
Thank you. And then just one more clarification.
Sure, proceed.
It's in that same, on page 4 of the bill. So it's 7C, where you move, you strike out any other relief under the medical care paid. Are we just moving any other relief under, I'm just trying to understand why it's being moved up under programs for assistance for, it's under financial literacy, then any other relief. Does that not tie to any medical care? Are we striking that? Or is it all encompassing and we just moved the section?
For the record, Heather Proctor, it is all encompassing. It is not, if you look to the provisions of subsection B where we are moving this, it includes coverage for medical care, for insurance benefits, counseling, all of those benefits. So the other relief is intended to be part of subsection B and within the $100,000 cap per calendar year.
Thank you so much. And we are returning to Member Gray again.
Thank you again, Madam Chair. Another question popped into my head. So it's not uncommon when you have a claim pending before the federal government, and it's even founded, that if the individual dies, the claim goes away. It's not paid to the estate, it just goes away. So in the case of either a posthumous exoneration or somebody who dies while they're waiting for their claim to be adjudicated, what happens? Does the estate get to finish it out, or?
Aaron Ford, for the record, Assemblyman Gray, you have us stumped on that one. We don't know what the survivability issue is, what the response would be from a survivorship perspective on this particular case. We've never had to deal with that at this juncture, and frankly would have to research to ascertain what the intent was of this body at that time.
Thank you, I appreciate that. And I'm really interested in the posthumous exoneration.
Okay.
For the record, Heather Proctor. Just to clarify, the intent of the bill is to assist the defendant in regaining their hold once they have been released from prison. So it is not intended for a posthumous award for the certificate of innocence. If you are asking what happens if the individual dies once they have been granted a certificate of innocence, that is the question we are not able to address at this time.
Thank you so much. With that, not seeing any additional questions, I will go ahead and open it up for testimony in support of Assembly Bill 63. Anyone wishing to come forward here in Carson City to support Assembly Bill 63, please come forward. Not seeing anyone. Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you please open the lines?
If you would like to testify in support of Assembly Bill 63, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for testimony in opposition of Assembly Bill 63. Not seeing anyone approach here in Carson City. Is there anyone there in Las Vegas? Not seeing anyone. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 63, please press star 9 now. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone wishing to testify in neutral? Not seeing anyone here in Carson or in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in neutral to Assembly Bill 63, please press star 9 now to take your place in the queue.
Good morning. Tanya Brown, TONJA, advocates for the inmates and the innocent. I'd like to thank the presenters on this bill. Thank you, committee, for listening to this. And we are in neutral right now. I'd like to thank some of the members for their questions, particularly Assemblymember Gray, dealing with posthumous exonerations. Now, I have some questions. And so let's see, how many people have passed away prior to being judicially exonerated or filed a petition for exoneration have passed away, who have been on parole and probation, who have passed away prior to the compensation being paid? As a person who has had a loved one spending 21 years in prison for a crime he didn't commit, was about to file a motion, his attorneys, for new trial and bail based on newly discovered evidence, and passed away prior to the motions being filed. And so I just want to say that I think if we're going to fix this, we need to include the decedents in this posthumously. Because even though they may have passed away, their families have moved on, and they're unable to move on. Some have families, some of them have struggled their whole lifetime because of what happened to their loved ones. They should be compensated for what they want. And if you've listened to some of the audios that I sent or about to, from those who've been wrongfully convicted and asked how they felt about if they had passed away prior to being exonerated, they would say they wanted their names cleared, and they should be compensated. Their families should be compensated. So these are some of the questions. So we are in neutral. Thank you so much for bringing this forward. I love the questions you members have asked, and please include posthumous exonerations, compensation for this. Just because they're dead, it shouldn't stop there. Thank you very much, and have a lovely day.
Thank you so much. Next caller.
Chair, there are no other callers to testify at this time.
Thank you. Then I will go ahead and close testimony and invite Okay, Attorney General is waiving his right for final comments. With that, thank you so much for being here today, and I will go ahead and close the hearing on Assembly Bill 63. 1 minute, 14-second recess. Hold on. All right, I will go ahead and open the hearing for Assembly Bill 218. Assembly Bill 218 requires the court administrator in each court in this state to establish a program to send certain communications regarding court proceedings by text message. I will give the presenters, including Member Gonzalez, a few minutes to get situated. And whenever you are ready, please proceed. Please remember to state your name and spell it clearly for the record. Assembly member, please also introduce your guest and have them spell their names. Okay, so we are ready whenever you are.
Thank you, Chair Miller and members of the Assembly Judiciary on the Assembly Committee on Judiciary. Good morning, everyone. Very excited for my first bill presentation of this session and to be in my favorite committee. I'm happy to be here presenting Assembly Bill 218. I'm sorry, again, for the record, my name is Cecilia Gonzalez, C-E-C-E-L-I-A, Gonzalez, G-O-N-Z-A-L-E-Z. With me today, I have Nick Shepak, Nevada State Director of Fines and Fees Justice Center, and Leslie Turner, the Nevada State Deputy Director of the Fines and Fees Justice Center, who will also be presenting this bill with me today. Assembly Bill 218 addresses a critical need to improve court appearance rates and compliance through modernized communication methods. Missing a court appearance can result in serious consequences, such as fines, fees, warrants, and even jail time for those who fail to appear. It also costs the court and the opposing party time, money, and resources. Various municipalities and judicial jurisdictions have already implemented these programs. One notable one is Colorado, which recognizes the need for such measures and implemented a similar text reminder program as recent as 2022. We have other examples that we'll get into in the presentation. I also want to note that Assembly Bill 218 seeks to adopt evidence-based strategies for Nevada. Assembly Bill 218 includes several key components designed to enhance the efficiency of court communication across our state. I will now turn it over to Nick and Leslie, who will go through section by sections of the bill. Thank you.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center. Fines and Fees Justice Center is a nonpartisan, nonprofit that seeks to address issues in the criminal legal system anytime fines or fees or other monetary sanctions come into play. We have worked on many bills with many of you through this legislature, or through different legislative sessions. Today we are excited to present this bill to you, and I will pass it over to our Deputy Director, Leslie Turner, for a brief presentation, and then I will walk you through the conceptual amendment we have, and then we'll be happy to take your questions. Thank you.
Good morning, Leslie Turner. That's Leslie-Turner. I'm going to walk through the slides quickly. First of all, court reminders is a pretty basic concept. I think we all get text reminders from our doctor's office, from any other appointments we might have from the DMV. So I think, and also that it's backed by science. I think that that's really important here. It's based on human behavior. So even up to the amount of texts that you get and when is all based on science. So I know that we're going to provide a lot of that data to you all. The Pew Research Institute and Ideas 42 have done extensive research, which will be sent over to you all. But essentially, it saves money and it saves time. Each missed court date can be $1,400. If we multiply that by the number of people who have missed court that we can document through failures to appear, we could save the state over $1 million. Assemblymember Gonzalez already spoke to kind of the consequences related to this issue. People get bench warrants, people can get arrested, but also people's time is wasted. Victims, they have to change their court dates. So I think that everybody in this situation can benefit. This is just some of the data that we were able to collect. We were able to kind of survey 6 of the courts here in Nevada. That was Sparks, Henderson Justice, Henderson Municipal, Sparks Municipal, Reno Municipal, and North Las Vegas Municipal. Those are the courts that we were able to collect FTA data. A lot of the other courts didn't have that data available, but just based on those courts, there were 4,200 failures to appear. So again, if we're able to save $1,400 for each court date that is missed, that could be over $1 million saved for the state, just with people going to court. Again, there is extensive research, which we will send over from Pew and also Ideas 42, that shows that once we start sending text messages, there is a 20 to 40% increased rate in people going to court. So there is, I think, a conception that people just don't want to go to court, and a lot of the times people do forget. I like to give the example of a doctor's appointment that I had the other day where I literally forgot about it until they texted me, a couple of hours before the appointment. So it's very common that people do just forget. There are obviously other barriers to going to court, but again, nationally, it's showing a 20 to 40% increase in people going to court once they start getting consistent text messages. Colorado, New York, Texas have all seen major increases in their major decreases in their failures to appear. And so again, that's kind of what the aim is for Nevada.
Thank you. Nick Shepak for the record again. So we have been working diligently with the courts and the AOC to craft an amendment to this bill. When we initially wrote this bill, we put in all of the best practices. One of the issues that came up was that being over-prescriptive to how courts set their processes may raise some constitutional concerns. And through conversations with the AOC, we also realized that if we added a best practices or research-based amendment instead of being overly prescriptive in statute, as information changes, as courts develop these programs, find out what works and what doesn't, it'll give the courts ample flexibility to continue to grow their programs, especially as technology and information becomes available. So to run through the sections briefly, Section 1, subsection 1 simply requires courts to establish a text reminder program. And these programs, as Leslie mentioned, are evidence-based. They're being implemented across the country. They see huge reductions in FTAs, which result in, again, court time is wasted when somebody doesn't show up. Police time is wasted. People end up in jails, or jails have high rates of people on FTA warrants. Victims show up for hearings where they're expecting the victimizer to be prosecuted, and that individual does not show up. Really, every stakeholder, from the public defenders to the prosecutors, benefit from these programs. Subsection 2, we added a provision that says that it is an opt-out program. Essentially, upon arrest, a defendant provides their information, or when they get a citation, it's in the bill that it is required, it is 100% on the defendant to provide accurate information. If they provide false information or no information to law enforcement, that is on the defendant. but they have to choose to opt out of these programs. When Colorado switched from an opt-in to an opt-out program, they saw a massive jump, as much as 61% in one county in reduction of failure to appear. So these opt-in programs are the most scientifically based. At the request of the courts and the AOC, we essentially scrapped subsection 3, which was the outlining the current best practices for court reminders, replacing it with court reminder programs shall be established based on research and best practices. Of course, that language, because this is conceptual, will go through the LCB to match similar types of requirements in the NRS. And again, this gives courts the ability to continue to learn, grow, and change their practices as they move forward. And then we deleted subsections 4 and 5 in their entirety. This again was at the request of the Administrative Office of the courts. The research program appeared to be overburdensome, and when we talked to friends who had worked in Colorado, they found that a lot of the court data that was actually collected did not end up being helpful, and there hasn't been a well-designed statewide program to do the research on this. So instead of copying something that doesn't work, we essentially removed that. Section 2, which is how information is gathered, we're leaving that the same. Essentially, time of arrest or citation, the officer conducting the arrest or the citation, or the booking officer, will take down the defendant's information. Now, we have been working very diligently with all stakeholders on this amendment. This morning I find out that some positions may have changed without our knowledge until just before this, that constitutional concerns may continue, that in fact some individuals may believe that you all do not have the right to tell the judicial branch to implement these types of programs. I'm not a lawyer, however, our research, we disagree with this stance due to the fact that you all set the penalties for what happens when somebody doesn't show up to court, whether that is a warrant for arrest with a shall be arrested, or whether that is a driver's license suspension. We believe it is also the duty and responsibility of the legislative branch to set up processes that ensure that people have the best opportunity to make it to court so they do not face these consequences. And bills like this have passed in other states, as mentioned, the most recent one in Colorado, which was significantly more prescriptive than what we were attempting to do here with the amendment. And with that, we would be happy to take any questions you may have.
Thank you so much. The idea that we don't have the right to create laws is still ringing in the air. But with that, I just have a quick clarifying question. On your removal from subsection 3, and you said removing the best practices and allowing LCB to come up with a language that would, the question isn't, I guess the question is, are you expecting or anticipating that language would be provided, creating kind of the policies around it? I'll let you answer that part first.
Nick Sheepak for the record. No, the language is court reminder programs shall be established using like research, right? So it allows the courts to determine what available research there is and then base those programs on that. The LCB or the legislature will not be prescripting what those best practices are.
Okay. And so with that, then my concern is the, we all know inconsistency is often an issue. So have you thought of how we could address any inconsistencies on how each different court or municipality delivers?
Nick Sheepak for the record. I mean, I agree fully, Chair, and thank you for the question, that having an ununified court system tends to lead to a variety of practices in all parts of our judicial system. We believe that working closely with the AOC, who has a court management program that, and they can correct me if this number is wrong, but I believe 35 courts are currently using, that the AOC would set essentially what best practices are. We would hopefully anticipate that most courts would follow these processes. We, as full-time fines and fees Justice Center members would be working diligently with courts through the implementation process. Again, we are not opposed to prescriptive language in the legislation. However, we do feel that this addresses the concerns that were held pretty unanimously by all stakeholders in the judicial system.
Thank you, and I do appreciate the position of permissive rather than prescriptive. It's just also trying sometimes for that, to address inconsistency so that justice isn't delivered depending on which city you're in. So thank you for that. With that, we will open it up to member questions, beginning with Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this. I agree. I think this is an important issue, but my question is, in talking to court employees around, obviously, Washoe, that's where I am, some are trying to send text messages, and I think the issue is obviously it's inconsistent. But when I talked to them, they spoke to me about an issue of carriers not allowing certain terms to be sent via text, specifically things about drugs or alcohol or firearms. And so as they're trying to remind folks of their issues surrounding those topics, they were being banned by the carrier. And I know this is probably a left field question. So my question is just, is there a way we can work with carriers, or has Colorado figured out a way of getting around that so that we can get the information that people need on a regular basis?
Nick Sheepak for the record. Thank you for the question. May I go direct, Chair? Thank you. Thank you, Assemblymember LaRue Hatch. So, yes, there are many courts who have figured this out. The best practices, essentially, when you look at the best practices for sending out these messages, what is in them is, it doesn't have to be overly prescriptive about what your charge is. It is that you have a court date. It is the consequence for missing that court date. It is a link to the website in case you need to contact the court because there is some reason you are unable to make that court date, right? And it's sent 3 times, ideally 7 days, 3 days, 1 day before. But you would avoid those types of terms in these messages, and it would be simple, very similar to your Olive Garden reminder that lets you know that you have scheduled dinner, or my favorite is the Carson Valley Hot Springs has a wonderful court reminder or text reminder program.
Thank you. Again, I don't know who forgets dinner, but okay. With that, we will have a question from Assemblymember Hardy.
Thank you, Chair. Thank you for bringing this bill. It's, I think, an interesting concept. So you mentioned that upon arrest or citation, the individual would have they can say, yes, I want to participate, or no, I don't, and then provide the information. And then elsewhere it says if they have any changes, like they change their phone number or whatever. So I'm just wondering, like, if they do change their phone number and then, the court's sending messages to the other number, is it again on the person to like update the court, and if they don't, the court's not going to be like trying to find them and figure out if their number's different?
Nick Sheepak for the record. Thank you for the question, Assemblymember Hardy. And yes, correct. It is the onus is on the individual, right? If there's a change in the individual's contact information and they want to update that, the onus is on that individual. Some people will inevitably fall through the cracks. They will get a new number. They will not update. They will unfortunately not receive these messages, right? This happens with certain indigent individuals, and especially our homeless population, who tend to have like a high turnover. Unfortunately, no one has figured out how to fully address that issue. But what we know is that when we establish these programs, take those numbers at the time of citation and arrest, consistently we see a 20 to 40% reduction in failure to appear. So while we can't really address every single nuance in a piece of legislation like this, we can have a significant impact.
Thank you. Our next question is from Assemblymember Gray.
Thank you, Madam Chair. Good morning. Good bill. I don't know who would forget a court date. Honestly, if I had a court date, I would be like awake for days and suffering a nervous breakdown. However, there are those people. My question is, though, can this be expanded to other key players in the trial, like maybe the victim, the law enforcement officer, people that need to be there?
Nick Sheepek for the record. I was actually talking, and thank you, Assembly Member, for the question. I was actually talking with some victims' rights advocates. We would love to see it expanded. The question is capacity, and we'd have to have that conversation with the courts. But ideally, in a perfect tech system, everybody who was due to be in court that day would get notified. I don't have a good answer based on how we collect the information, right, as it is currently at time of arrest and time of citation is where most people collect that information. It may be a question that courts who already have text message programs could answer, but ideally those individuals would be included.
Thank you so much. Our next question is from Assemblymember Cole.
Thank you very much for this bill. I do appreciate it. My question is in Section 2, subsection 2C, where we talk about the juveniles that are in the court system, right? And you're asking for the telephone number of the child. I'm just wondering if you should also include the telephone number of the adult or the guardian that the child was released to. That might be helpful.
Nick Sheepek, for the record, I think that is a great idea, Assembly Member, and we would be happy to amend that to include parents and guardians.
Our next question is from Assemblywoman Moore.
Thank you, Chair, and thank you for bringing this bill forward. I do have a question. I know that we're going with text messages and other states have adopted this. Do you know, or are you aware if any other states are emailing folks to remind them about their court dates?
Nick Sheepek, for the record, yes. Thank you for the question, Assembly Member. And yes, other states are absolutely, and so are we. We're using nothing in this is intended to bar courts from using as many forms of communication or any form of communication they're already using. However, all of the research shows that text messages are the most effective. If your inbox on your personal email looks anything like mine, like I am not seeing things the same way I am on my phone. So we originally had in there, if you can't email, if you can't have a phone number, maybe you try the email. Many courts are already doing this. We simplified the bill to use the most effective means, but we encourage all courts to use multiple forms of communication when available and when practical.
Thank you. And with that, that will conclude our member questions. So I will go ahead and open it up for testimony in support of Assembly Bill 218. Beginning first in Carson City. And I don't see anyone in Las Vegas, so we'll jump to the phones after this. And yes, please fill the chairs and just kind of rotate out.
Good morning, Chair Miller, members of the committee. My name is John Abel, John-Abel, representing Public Safety Alliance of Nevada and LVPPA in support of this bill. As I was sitting here, I was Googling the different programs that the government can use to text you. If Discount Tire can text you that your car is done, if the VA can text you, if my daughter's doctor can text me, surely we can figure out the bureaucratic processes to get this program started. So for that reason, we support it. Thank you.
Good morning, Paloma Guerrero, Paloma Guerrero, Clark County Public Defender's Office. We are in very strong support of this bill. Every day we see clients who miss their court date, not because they're trying to avoid justice, but simply because they forget, misunderstand, or have lost the small sticky note size notice of when their next court hearing is. Many of our clients face housing instability. They have multiple jobs and have kids to care for, which makes it really easy for these court dates to just fall through the cracks. This bill is a simple act that's going to have great impact on our clients. When someone misses court, they risk a bench warrant, they risk arrest, and they risk unnecessary incarceration. So this bill ensures that people can take take care of the case and also stay with their families. Thank you.
Angela Knott from the Washoe County Public Defender's Office. We are in support of Assembly Bill 218. This is a simple tool and it will have a significant impact on all of our clients. Thank you.
Good morning. My name is Tia Smith, TIA-SMITH. I'm a policy attorney with the ACLU of Nevada, and the ACLU of Nevada supports AB 218. Thank you.
Good morning, Chair Miller and members of the committee. My name is Riley Svensson, RYLEYSVENDSEN, and I am the policy specialist for the Nevada Coalition to End Domestic and Sexual Violence. We thank the Fines and Fees Justice Center for their work to include victim survivors in this legislation and look forward to continue working with them through this process. For victim survivors of domestic and sexual violence, court can represent a time to heal. However, it can also be extremely re-traumatizing, triggering, and anxiety-inducing. Victim survivors are forced to face their abusers, are subject to cross-examination that is too often mired in victim blaming, and must relive the abuse that they experience. Because of this, leading up to a court hearing, victim survivors may spend weeks, if not months, emotionally preparing for the day. So often, there's so much pressure put on court hearings, which are looked to as beacons of hope. An opportunity to share one's experience, to receive some sense of solace, safety, and closure when one has been living in fear for far too long. But this can only happen if the defendant shows up. Having a proven system in place to remind defendants of upcoming court hearings can help with the closure, healing, and safety of victim survivors. And because of this, I encourage you to support AB 218. Thank you.
Good morning, Chair Miller, committee members. My name is Harrison Porter, HARRISON PORTER, and I represent the Las Vegas Police Managers and Supervisors Association. I'd just like to echo our support for this bill. Thank you.
Broadcasting, will you open the lines, please, for testimony and support?
If you would like to testify in support of Assembly Bill 218, please press star 9 now to take your place in the queue.
Hello, good morning. My name is Yesenia Moya, Yesenia Moya. I'm speaking in support of AB 218. This bill is a common sense measure that improves government efficiency by implementing text message reminders. As folks have already said, these show that people will come to court, reduces failures to appear, and leads to fewer warrants and fewer people in jail. I know firsthand how difficult it is to keep track of a court date, especially if it changes. And many people don't have the navigational skills to understand the different scheduling and how to look it up online. So court notices can be confusing. Even missing a date by accident can have serious consequences. On top of that, just getting to court can be expensive, from parking fees to taking time off of work. So a simple text reminder would make a huge difference for so many of us just trying to navigate the system. And I don't believe this is about interfering with judicial discretion, but it is about providing courts with a proven tool that improves attendance and reduces administrative burdens. In fact, if you simply Google quote unquote, how to implement a court text reminder, you'll find toolkits from across the country and other national orgs that provide a clear blueprint for courts to set up these programs. AB 218 ensures the judicial system runs more efficiently, reduces unnecessary costs, and benefits the entire community. And I urge your support. Thank you.
If you have recently joined and would like to testify in support of Assembly Bill 218, please press star 9 now to take your place in the queue.
Good
Follow with the
afternoon,
last
Chair
three
and members
digits.
of
You
the
may
committee.
begin. You may begin.
Good afternoon, Chair and members of the committee. My name is Tara Webster, Tarawebstr. I'm calling on behalf of the Progressive Leadership Alliance of Nevada in support of AB 218. This bill addresses the economic burden and inefficiency of the current court reminder system, and it also creates a pathway for everyday citizens, particularly those from marginalized communities that we represent at Plan, to avoid severe consequences, including going to collections, losing their driver's license, and incurring additional fees or facing criminal charges. Again, on behalf of Plan, we urge your support for AB 218. Thank you.
Chair, there are no other callers to testify in support at this time.
Thank you. With that, I will open it up for testimony in opposition of Assembly Bill 218.
Good morning. My name is Catherine Stocks, for the record. Katherine Thank you for the opportunity to be here. It's always a little rough being on this other side here. But the reason that I'm here in opposition, I am the state court administrator. And based on the comments that have already come from the delivery of the bill, this is a good bill with good intentions. The reason we're here in opposition is based on the mechanisms. And as Mr. Shepak said, there was a proposed amendment cutting out, I think, sections 3, 4, and 5, which were of concern about the autonomy of the judiciary. However, I'm here with another piece of information. So the AOC has a case management system that is deployed in our smaller jurisdictions across the state. We have been doing text messaging since 2022. We've sent over 190,000 texts out as court reminders. Those are both before your court date. They're also about payments due. If you're on a payment plan, a reminder that you have a payment due on your payment plan. So we're already doing the work of the intention of this bill, and we're really proud of ourselves for being ahead of that. We also, with that, if there's any specific questions about the content and text within those, I'm happy to provide that. But I'm also going to try to keep this a little bit shorter than my prepared remarks. So because some of our courts are already addressing the intent of the legislation, we are coming to the table in opposition with a proposed solution. We do say thank you to the work that's already been done up until today, and we hope that we can continue that work going forward. Our proposed solution, though, is rather than imposing a statutory requirement, the desired outcome of improved litigant communication can be achieved through a review or revision of existing court rules. For example, we recently...
Ma'am?
Oh, sorry.
So we're already over time.
Oh,
so
where's the... Okay. Apologies.
I mean, I would love a shot clock in here, but
Yep.
they keep saying no every time I ask.
I appreciate it. I apologize.
But,
that would be great. Okay.
But with that, if
Questions?
you could just wrap it up.
Certainly.
Thank you.
Okay, just like our ADKT where we had the Virtual Advocacy Commission, that is our proposal of allowing this to be done through court rule. And then we also ask if it would be, if the legislature, we know that Money Committee is not the purview of this, but that is also asking if there could be an appropriation for an effective rollout. Thank you.
Thank you so much. And with that, of course, I know that the bill sponsor will be happy to discuss further with you. Thank you.
Thank you.
Thank you, Madam Chair. My name is Tom Clark. That's Tomclark. I'm here on behalf of the Nevada Judges of Limited Jurisdiction. We are in opposition because the bill as it was written, we were opposed to. However, I give Mr. Shepak a lot of credit. He's worked very closely with us as stakeholders in this deliberation. We also work very closely with the AOC, and we look forward to really getting this to a final determination as to how we can best ensure that these systems are implemented by each of the individual courts going forward. So thank you, Madam Chair.
Thank you. Not seeing anyone else approach for testimony? Broadcasting, will you please open the lines?
If you would like to testify in opposition to Assembly Bill 218, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in opposition at this time.
Thank you so much. Is there anyone here in Carson that would like to testify in neutral? Not seeing anyone. Broadcasting, will you open the lines for neutral testimony?
If you would like to testify in neutral for Assembly Bill 218, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify in neutral at this time.
Thank you. Then I will close testimony and welcome the bill sponsor up for any final brief remarks.
Thank you so much, Chair. Again, for the record, Cecilia Gonzalez. I just want to say thank you to everybody who's working on this piece of legislation. I learned of opposition this morning, and so I look forward to continuing the conversation, the work that we've been doing. Assembly Bill 218 is a common sense measure designed to improve court efficiency, to reduce failure to appears, and ensure that individuals have information that they need to navigate a very complex court system. And so I urge you all for your support, and thank you so much for the opportunity to present AB 218 to you this morning. Thank you.
Thank you so much. With that, I will go ahead and close the hearing on Assembly Bill 218. The last item we have on today's agenda is public comment. Again, I ask that people please keep their comments to 2 minutes. We will begin here in Carson City if there's anyone that would like to approach and make public comment. Not seeing anyone here in Carson. Also, there is no one in Las Vegas. Broadcasting, will you please open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue.
Good morning. Tanya Brown, TONJABROWN, advocate for the inmates and the innocent. I'm coming back under the public comment for a couple of reasons. First off, under the public comment, when you submit a document or anything else, you don't know what's going to happen during testimony that's given. Like, for example, for today, we were unable to see the amendment to AB 63, so we came in as in neutral. We have provided you a document that we had sent to the AG's office a few weeks ago with our friendly amendment to SB 66. It is a factual innocence posthumous petition, and SB 66 is dealing with petitions, and it is being sponsored by the Attorney General's office. I'm asking the chair, Madam Chair, to please accept our document for the public record, our amendment and the email, because we have to provide according to the 24 hours in advance. Well, we don't know public comment, what's going to be said, what's going to be presented, what's going to be the amendments or anything else. So we can't give a comment 24 hours. We can during the testimony, but not under public comment. And so I'm bringing it this way. And again, you know the history of what happened. There are other people out there. I have sent you some audios of the exonerees who testified at the pardons board. And this really surprises me with the Attorney General's board, him not wanting to do this. When you look at his past history on wanting to do everything for those who've been wrongfully convicted, why is he stopping this one? From not moving forward? It should be included in that bill. Again, like I said, just because one passes doesn't mean that justice for them should not stop there. Look at everything they lost. The families who've lost everything. And again, we don't have the statistics on those who've been judicially exonerated and have not received compensation, or who are about to, who are on parole.
Ms. Brown?
As it stands now, if the bill moves forward, 63, we are
Ms. Brown, we're over time.
We will be in opposition. Thank you. I appreciate it, and please take it to heart.
Yes.
What we are advocating for is for justice. Thank you. Have a great day.
Thank you so much, Ms. Brown. And just to clarify too on that technicality, individuals, groups, people, everyone, you are able to submit testimony as well as public comment up to 24 hours after the hearing as well. So the requirement for submitting, if you want something to be part of an exhibit or a proposed amendment or a presentation, certainly that's 24 hours before, because the expectation is that's going to be part of the presentation. But absolutely, we know that the whole purpose of the hearing is for people to make decisions, understand the issues, and take their positions. And sometimes that doesn't happen until during or sometimes even immediately after a hearing. So you do have up to 24 hours after a hearing to submit comments or testimony. So just to clarify that as well. With that, next caller, please.
If you have recently joined and would like to provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT, advocate for the inmates and the innocent. I would just like to echo my colleague, Ms. Brown's previous comments. We need posthumous exonerations. The stigma that these families carry of family members of the wrongfully convicted, I've personally witnessed what family members have to endure with the stigma that they carry around when their loved one has been wrongfully convicted, and you've tried every avenue that is supposedly available to you to clear your loved one's name, and you get nowhere. So we need it by law, posthumous exonerations for the wrongfully convicted. The ultimate in miscarriage of justice is dying in jail or prison, an innocent person. Thank you.
Thank you. Next caller.
Chair, the public line is open and working. There are no other callers to testify at this time.
Thank you so much. Then I will go ahead and close public comment. With that, that concludes our work for today in this committee. Thank you, members and presenters and everyone else. I will go ahead and adjourn this meeting and see you all tomorrow at 8 a.m. This meeting is adjourned.